Yes, it's official. The Tenant Protection Act, or AB 1482, in the state of California has officially changed. In this quick guide for renters and landlords, we are going to run through the changes that SB 567 brings now that we have passed April 1st, 2024. And stick around to the end because we're going to give a quick tour of some of the new forms that need to be used now that the Tenant Protection Act has changed. Hey there! Christian Walsh, real estate agent with Wire Associates. We've been helping renters and landlords understand their rights before things go wrong. And remember, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. So first, a quick run through what is the Tenant Protection Act. Well, it does two things throughout the entire state of California. Number one is it caps rent increases for properties that are subject to it. So a rent increase within a 12-month period cannot be any higher than 5% plus the consumer price index, the CPI, with a max cap of 10%. And I've done another video that you can watch to go ahead and see what the maximum rent increase is for your area this year. There's a link above and a link below. And the other half of AB 1482 are the just cause protections. Again, for properties subject to AB 1482, there are very specific reasons that a landlord can terminate a tenancy for a no-fault reason. And by no fault, we mean the tenant hasn't done anything wrong. The landlord will also be required to pay relocation assistance in the event that they are using one of these no-fault just cause reasons to terminate a tenancy. And here's a quick run through on which properties are exempt and which are subject to AB 1482. So most houses and condos are exempt from AB 1482 as long as they aren't owned by an LLC with a corporate member. So trusts are okay, LLCs where it's individuals in the LLC, those are fine. Those properties remain exempt from AB 1482. An owner-occupied duplex would be another example of a property exempt from AB 1482 as long as a landlord has been there the entire time that the tenant has. And the other big category of exempt properties are no matter how many units, 15 years and younger. So it could be 1 unit or 100 units. If it's less than 15 years old, and that's a rolling date, that property is exempt from AB 1482. And the last vital detail to make sure a property is exempt from the Tenant Protection Act, the tenant must receive this exemption language right here. That's specifically what the law says a tenant must receive. This form is the rent cap just cause addendum from the California Association of Realtors. It includes other information as well. And by being exempt, that means there's no cap to rent increases. Theoretically, rents can be raised as much as a landlord wants, and you don't need a just cause, no fault reason to terminate a tenancy. That 60-day notice for a month-to-month renter can be given for any reason at all. No specific reason must be given. So which rental properties are subject to AB 1482, meaning these laws are in place? That would be anything with 2 units or larger, as long as the 2 units are tenant occupied, and anything 15 years or older. So if a property falls into that category, it is subject to AB 1482 and some of the changes we're about to run through. And AB 1482, or the Tenant Protection Act, is at the statewide level, so it covers all properties in the state of California. It is very important to note that some areas have more strict laws in place, so you need to know whether your local municipality or city or county has a more strict just cause or rent cap bill in place. Here's a quick run through of some of the differences between AB 1482 before April 1st, 2024 and after April 1st, 2024, which is when you're watching this. These changes are thanks to SB 567. Number one and very important detail is it does not change the properties that are exempt from the Tenant Protection Act. So if you're exempt before April 1st, you remain exempt after April 1st. So the big changes after April 1st are related to owner or family move into the unit before 1 month relocation, 60-day notice, check that box, good to go. After April 1st, big changes. Still the 1 month relocation assistance, still a 60-day notice, but there's new language on there. And specifically, you're going to have to disclose as a landlord how those folks are related to you that are moving in. And the tenant can ask for proof of that. And the family member of the owner must move in within 90 days after the renter has moved out. And they have to stay there a full 12 months. If they don't meet these requirements, the renter can move back in and pay the same rent that they were paying before. A substantial remodel or demolition of the property before April 1st, 1 month relocation assistance, check that box on the 60-day notice. Now things are different. You have to pull the permits ahead of time, give those to the renter. There's required statutory language, still pay the 1 month relocation assistance unless the local area requires more. The notice itself is going to have a description of what's going to happen for the work, and we'll show you on the form what happens if it isn't demolished or remodeled, and if the renter wants to move back in after the remodel. We're going to run through those in the paperwork. Another big change in AB 1482 is now there's more teeth to it. There's more bite. In the past, before April 1st, there wasn't much that the tenant could do if a landlord did not follow the rules. They could use it as affirmative defense against an eviction, but it would have to move all the way to an unlawful detainer. Now, there were some larger cases. Attorney General Bonta did go after a property management company that had overcharged a significant number of renters, so there was a lot of money on the line for that one. Now the renter can bring civil action for damages against the landlord in the event that they don't follow AB 1482 or abuse AB 1482. So it's very important before terminating a tenancy, as I always say, that the landlord should reach out to a real estate attorney to discuss. Don't forget, we're real estate agents based in Southern California. Don't even think of terminating a tenancy to sell a property without talking to us first, no matter where you are in the state of California. Taking a quick run through the new forms, brand new for terminating a tenancy through the California Association of Realtors. You don't have to use the exact ones, but these show you some of the new changes. We're going to do longer videos. So this is the instruction page. The notice of termination of tenancy is intended for periodic tenancies. Do not forget that if a tenant is on a fixed term tenant, for example, 1-year lease, you can't terminate it right in the middle. It has to be periodic, month to month, for example. Then you can do a termination. So this form, again, we're going to do a longer video on this, but it covers properties subject to the Tenant Protection Act or exempt from the Tenant Protection Act. You pick one or the other because a property is one or the other. And then in here, it references some new forms. So if the owner is going to take advantage of family move-in on a property that's subject to the Tenant Protection Act, there's a new form here, the NTTFM. And then if the owner is going to demolish or remodel, it's the NTTRD. So scrolling on through, again, we'll do a longer video. So this is the family move-in disclosure and addendum. This is the NTTFM, and it shows what needs to happen. So for properties where there will be owner movement subject to the Tenant Protection Act, the names of the family member in relationship to the owner have to go on here. The tenant can request more information to verify they're actually relatives, and it gives definitions to these. And here's the addendum. So this would be added to the notice to terminate tenancy if a landlord is going to be terminating the tenancy for a Tenant Protection Act property, and they're going to do a substantial remodel or demolition. It has the required statutory statement that states if a landlord gives this notice and then does not tear down the property or does not do the substantial remodel, the tenant can move back in and they will pay the same rate as before they moved out. You have to have a description of the remodel, what's going to happen. You have to say how long it's going to take. If it's going to be demolished, you have to put a date of the expected demolition. And then this is important not to be confused with the statutory statement. If the tenant is interested in moving back into the rental unit after the remodel is done, they can let the landlord know. The landlord does not have to offer it at the same price as pre-remodel. They can go ahead and offer it at a new price now that it's been upgraded and remodeled, and then the renter must qualify for that new rate. So that's important. That is distinct from the landlord not remodeling the unit. The tenant can move back in and pay the same amount. If it's been remodeled, the tenant can move back in, but they're not required to be offered the same amount of rent as they were before it was remodeled. Hopefully that makes sense. If you've enjoyed this information, want to make sure you know about the next updates to California landlord-tenant legislation, make sure you subscribe to our free weekly email newsletter. We'll gently deliver that to your email inbox every Sunday with the latest updates. If you like this video, the next thing you need to know is in this video right here. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we can't wait to hear from you.